So the lawyer who's arguing the case that a corporation should be able to deny its employees access to contraception on the basis of their religious beliefs. The lawyer is arguing that case, and he gets out 1.5 sentences of his argument when he is interrupted by Justice Sonia Sotomayor. She says, "Is your claim limited to contraceptives, or does it include items like blood transfusions, vaccines, for some religions, products made of pork? Could an employer preclude the use of those items as well?" The lawyer gets out 2.5 sentences in response to Justice Sotomayor, whereupon he gets interrupted again, this time by Justice Elena Kagan, who says this: "Just take one of the things that Justice Sotomayor asked about, which is vaccinations, because there are many people who have religious objections to vaccinations. Suppose an employer refused to fund vaccinations for employees. What happens then?" The lawyer gets out 2 more sentences, and then Justice Kagan jumps in again, interrupts him, and asks, "Blood transfusions?" She says, "Blood transfusions? Could they refuse their employees getting blood transfusions on religious grounds?" The lawyer says at that point, each of these would have to be evaluated on its own. And then they struggled on through the first half of the argument. This is a case at the Supreme Court today that has been championed by conservatives and Republicans as a test of religious liberty. At its factual core, though, it really is about the question of whether or not your boss gets to decide on the basis of his or her religious beliefs whether or not your health insurance covers your birth control. Joining us now for the interview tonight is Walter Dellinger. He's a former acting Solicitor General and a presidential advisor on constitutional issues. He was at the Supreme Court for today's arguments. Mr. Dellinger, thank you so much for being here. I really appreciate your time tonight.
You're welcome.
From what you saw and heard in court today and the way this case was briefed, what is the key legal point that will decide this case, and how broadly applicable is it beyond the initial facts of this challenge?
Well, the key legal point that ought to decide the case is whether companies can use their economic leverage to impose their own moral views on their employees. I mean, no one doubts that the Green family has sincere objections to contraception, but they own a company that employs 13,000 people, and they want to impose their religious views on those 13,000 people. And if they succeed, as Justice Kagan pointed out later in the argument, Rachel, if they succeed in this claim of imposing their burden of their religious beliefs on their employees, they will both be denying the essential moral agency of those women as individuals. They will also be setting the stage for endless other claims, as Justice Kagan said, to come out of the woodwork. Claims about, I don't agree with the sex discrimination laws, I don't agree with the race discrimination laws, I don't agree with the Family Medical Leave Act, all on religious grounds. Therefore, I don't want any of my employees to have the benefit of those. And I think it's that the notion that we let people impose a burden on third parties, which is really where their religious rights ought to stop, when they subordinate the religious and moral views of other people.
So to be clear, there's nothing about this case that would limit the potential applicability of a ruling to just the Affordable Care Act or just health care. At least the more liberal justices today were making the case that this is something that could potentially give corporations the opportunity to opt out of any statute, even ones that are broadly seen as applicable to everyone.
Absolutely. Justice Kagan said that any corporation is going to be able to, or any commercial enterprise is going to be able to say, we have religious objections to complying with the law, whether it's an anti-discrimination law or a handicap law, we don't want to comply with it. And they would be entitled to win unless the government can meet some exceedingly demanding test of showing an especially strict form of a compelling governmental interest. And here I think what is really telling is how they disparage and diminish those who are seeking to uphold this religious exception, disparage the rights of the women who want to be making their own moral decisions and be responsible for their own moral choices. They also, I think, at times spoke today as if this were some sort of gift for the women from the employers that the employer wants to hold back. It's not a gift. This is part of an employment compensation package that these women have earned. They have contributed part of the premium themselves, and they have earned the rest of it as part of their employment compensation, just like Social Security. And this would be the first time in American history that a for-profit company had successfully claimed that it could be exempt from commercial regulations on religious grounds, and there's no telling where that would stop.
I know it is folly to make predictions on the basis of oral arguments, but you've seen a lot of them. You've argued before the court. Having seen what happened today, did you have a sense of which way the balance of the court might be leaning on this issue?
Rachel, I did not. Clear, I can tell you how 8 of the justices are going to vote, 4 on each side. Justice Kennedy at one point indicated he understood that this was a burden on the employees, on the women. At other times, he expressed concerns with the government's case. I really found it a case where it was not possible to read the direction of it. So it's going to be the last week in June. We're going to find out. It's possible they may find some narrow ground to decide this on, but it's something that's very important that's at stake. What people don't realize is that the most effective means of birth control are often the most expensive. IUDs can cost a month's salary for a minimum wage full-time worker. And if you take that outside of the insurance compensation package which these women have earned, you're really imposing a great burden on them for the benefit of their employers.
I thought about that today, reading Justice Scalia's remarks about how this doesn't really cost anything. This surely can't be anything too expensive. His lack of familiarity with the factual basis of the claim was striking today, something that you wrote about in advance of hearing today's arguments. Walter Dellinger, former Assistant Attorney General, former Acting Solicitor General, thank you so much for being with us. I really appreciate your time, sir.
Thank you.